Your job is to plan for everything to go right. Plan for success. My job is to plan for everything to go terribly wrong.
Welcome back to Franchise Reality Check, where we replace franchise hype with real due diligence. I'm your host, Genevieve McDaniel, founder of Franchise Reality Check, and my work focuses on helping prospective franchisees understand what they're actually getting into before they sign a franchise agreement. Because once you sign, the leverage shifts, and what you thought you were buying and what you actually agreed to can be two very different things. Today's episode is one I get asked about constantly. Do I really need a franchise attorney, and are the fees even worth it? So I brought on someone who works directly on the franchisee side of these deals, one of the few attorneys working in this space that only represents franchisees. My guest today is Kelly Spann, a franchise attorney with FortmanSpann based in the St. Louis area. Her firm works with franchisees across the country on acquisitions, agreement reviews, renewals, transfers, and disputes. Today, we're breaking down what a franchise attorney actually does, what they're looking for that most buyers miss, what can realistically be negotiated, and what happens when things go wrong. We're also going to get into something most people don't think about until it's too late: disputes, what they look like, how they're handled, and what your real options are once you're already in the system. Let's get into it. I'm so happy to have you on here today. I've admired your work for many years. As you know, you and I have worked together before. One thing that really strikes me about you is that you're one of the few franchise attorneys in the space that only works with franchisees. Like you don't work both sides of the fence. And I just really love that about you, that you're just committed to franchisees. And so what got you into just working with franchisees instead of flipping to where the money is, I guess?
I would say it kind of all, quite frankly, happened by accident. We were a general practice for many, many years. And then all of a sudden a franchise case came across our desk. Nobody else would take it. And we were like, let's give it a go. And we were successful at it. And then we just kept rolling from there. And quite frankly, I never jumped to the other side simply because it feels like, as an attorney, my job is to do what's in the best interest of my client, and solely my client. I have to do what's in their best interest ethically. We have all these ethical rules. Because I do what I do on the franchisee side, I know exactly what to do on the franchisor side to, quite frankly, screw over the franchisees. And ethically, I don't feel comfortable doing that. So I just don't put myself in the position to do that, which is kind of how it just kind of evolved. And I just feel like, do I understand the other side? Yes, I absolutely do. I understand where they're coming from. I understand how to do it in an ethical way. But I don't ever want to be put in a situation where I feel torn between representing my client and doing the right thing. So I always just stayed on the franchisee side. Plus, there's not a lot of people out there helping them. So I feel like I need to stay on this side.
Now, let's start with your path into being an attorney. You didn't come into this in the most traditional way. So kind of walk me through your path and how you got to be in this legal space.
I literally became an attorney by accident. It was not on my radar at all. I was actually working at an accounting firm, and John Fortman had an office space in the same building. One day his assistant had to quit for some family situation that was going on. Tax season had just ended. I had obviously known John from just walking past the desk and everything. And I was like, hey, I have a couple extra hours. I can at least help you answer the phone and do the things that you need to do until you find somebody. That ended up being, I want to say 3 weeks of me doing that. And he never, the interviews weren't going well. And I always joke that I don't know if I was so bored from tax returns that I found law absolutely fascinating, but I did. And I really liked working with him. So I was like, hey, what about me? That worked out. So I started there, and I literally just started basic secretary stuff, answering the phone, organizing files, the whole 9 yards. And then everywhere he went, And everything he did, I was watching and learning to the point where very quickly I was doing everything an attorney did. Fast forward many years, like more than a decade of doing this, all of a sudden one day he says, I'm going to want to retire, right? And I said, yeah. And he said, what are you going to do? And I said a cuss word. And then I said, I guess I'm going to law school. And you cannot own a law firm or practice law without having a law license. I was able to do it for so long because he was my oversight in reviewing everything I did. And ultimately his name was going on everything. So it wasn't an issue. But if he wasn't going to be there, it was going to be an issue. So I had to finish my bachelor's degree because I never even did that. So I finished my bachelor's degree online through Western Governors University, which was wonderful because you could test out of classes. So I think I finished my bachelor's degree in it was something ridiculous, like 22 months or something crazy. And then I applied to law school, went to law school, graduated law school, passed the bar. And the day I passed the bar, I became partners with John, and here we are. So it's been a wild ride. There was a lot of bumps and twists throughout all of that, but it was definitely never a set out path plan. It was just kind of, I followed the path and this is where it led me. And I truly believe it's where I'm meant to be.
So there was no need for any certifications, like paralegal certifications. Like you just jumped in, both feet, all arms, everything. Just, I'm going to do this.
100%.
Did he always represent franchisees before, or did he do a mix of law back then?
It was like a general practice back then. I tell everybody I've done everything from a traffic ticket to class action and everything in between. So I know enough to be really dangerous. Not necessarily practice all of those areas, but I know enough to issue spot and see and know how all those areas intertwine with what I'm doing. So we were a general practice for years. In fact, we didn't niche down to just franchise law until I took over. And then I niched it down to just franchise law.
Now, did you feel like your experience before you went into law school, it helped you in law school? Or was the law school experience just really just educational only?
The way I explain it is I already knew how to do everything. I didn't necessarily know the why. Right. So when I went to law school, it was very different than a lot of other law school students because I already knew how to do the how. So when I was learning, it was kind of really interesting because I was learning where the basis came from law and the law that I was applying. So it was I would say a deeper learn for me than the average person because I was like doing it the reverse way. But I would not tell you I actually learned a whole heck of a lot because I already knew how to do it. And the one thing they don't teach you in law school is how to do a dang thing. So when you leave law school, you you have to go under the supervision of somebody else because you don't know how to talk to a client. You don't know how to draft attorney contract. You don't know how to draft a petition. You don't know how to file it. You don't know, you still have to learn how to do everything, but in law school, you learn the why. So it was very different for me. It was also easier in the aspect that I already knew how to read law and apply it. That's a skill set. So a lot of people, they would have to read these cases multiple times just to try to understand, the legalese in it and figure out what the heck it said, where I could breeze through it and be like, okay, got it, because I've been doing it for years. So in that aspect, it was a lot quicker. Where the downside was I was working full time still, had 3 kids, and I'm competing against a bunch of law school students and peers that don't have those things. And in law school, the grading is scaled. So it depends on what your classmates do that can affect your grade. So that was my biggest fear, but it turned out I was just fine.
And that actually brings me to a question I didn't originally have for you. And that is, there's a huge controversy about AI replacing lawyers. You have these lawyers that are fresh out of law school, and like you said, they have to go under somebody. So what are your thoughts on the whole, we can use AI to draft documents and be pro se?
I am not worried about it. Um, so, based off of what I've seen, here's the difference. Do I think AI can help? Yes, I do think it can help, especially in like small claim situations. Totally makes sense. It can help you. What it cannot do is instinctively ask you the right questions. It's only going to take in what you give it. And if you are not trained in the law or trained in knowing how the situation affects everything as a whole, you're not going to know what information to give it. You're not going to know what information is important. The AI is not going to see you on the other side bawling your eyes out because you're losing everything. AI is not going to walk you through all of that. Can it help? Yes, but it's not going to replace. I shouldn't say this. I should say that if you are good at what you're doing as an attorney, you should not be threatened by it. I'm not threatened by it at all. Do I think it's a helpful tool? Yes, I certainly do. And I've used it before, but I actually use it pretty frequently. But it is a tool. It is not a replacement. The other thing I would say is it gives you a lot of misinformation. So lately, what I've been having to do is my lawyering work and guiding people has become more difficult because people are going to AI and AI is telling them what they want to hear. And then they come back to me and I go, that's not how it works in real life. And I have to almost like reverse everything to get us to platform level and then go forward. Where before people were just coming in at platform level and I was like, okay, here's what we're doing. Now I got to do all this undo work to get them back to here's what real life is, here's the reality of the situation, and then guide them forward.
Yeah. So for any franchisees out there listening to this podcast, ChatGPT is not a replacement for an actual lawyer. I'm going to go ahead and I want to talk about the moment when everything shifts for a franchisee. So the moment that they sign a franchise agreement, what changes for them?
I guess the easiest way to say it is the dynamic, the relationship that they've just entered into. I know people hate when I say this, especially franchise war attorneys, but it's kind of like a marriage. The second you walk down that aisle and the second you say I do and the second you sign that marriage certificate, it can change things. Sometimes not knowingly. Sometimes it's just like an internal change, but it does change things. It changes the legal dynamic going forward, and it immediately sets into flow the time frame for franchisees where you now have to comply with this agreement, and there's time frames to do it in, and it's an immediate go.
Yeah. So a lot of the things that I hear is that franchisees don't really realize, like in that moment, that anything has really changed. So they're in this mindset of, we're moving forward. This is a great idea. We're going to be the best at this. We're set up with X, Y, and Z to be the best. And then they get into it and then they realize that things are not what they thought. And there's certain leverages in there that they didn't consider when they signed or before they signed.
So when I'm doing the initial consultations before people sign, I warn them, not really warn them, but tell them your job is to plan for everything to go right. Plan for success. My job is to plan for everything to go terribly wrong. And if it does, here's what the contract says. The other thing that a good review does with an attorney who sits down and makes you understand what this contract legally does is it helps you issue spot. So if you're a franchisee, and even if you understand the contract and you decide you're going to go forward with it, that's great. As long as you understand that contract, the timeline that comes with it, what your rights are, what they're supposed to do as the franchisor, all of those things. So that if things start to go sideways, you can spot them quicker. Then you can reach back out to me quicker and we can get in there quicker and hopefully mitigate the damages quicker. A lot of times these franchisees have no idea what their rights are. So they're waiting and waiting and waiting. And quite frankly, this is a whole other topic we can talk about, but gaslighting absolutely exists in the franchise world. And they're getting gaslighted into believing that everything's going to be okay eventually until they are nearly out of funds. And then they call me. So if you go in educated on what your rights are and understand the dynamic you're getting into, it is far easier to succeed in the franchise investment model.
Yeah. So for me, I feel like there's not enough being done on that initial education side of things before they sign. And that's why I started doing this. Realistically, we all know we're not going to change the way that franchisors do business, but we can absolutely have an effect on the way people go into a structured deal, like a franchise agreement. There really is not enough people that are hiring attorneys to look things over. And when I ask people that come to me when everything's fallen apart, and I say, why didn't you have an attorney, a franchise attorney, look this over? Well, I had my friend down the street who's a business lawyer look it over and he gave it the green light. I'm like, so it's like, do people not understand that there's franchisee or franchise lawyers available for these reviews? Is it a matter of they don't want to spend the money on a franchise attorney? And then if so, like why? What? Because when you think about it, not hiring somebody like you to look at their documents, it puts their whole investment at risk. So for me, I would rather spend the money to whatever it is, $5,000, we'll just throw that out there, to have somebody bring me fully informed than to lose a six-figure investment later.
So I think it's a mixture of a lot of factors. The people selling the franchises are not regulated at all. They can tell them whatever the heck they want to tell them, including that this is standard. This is we're regulated. We file the FTC. We do all this stuff, and the franchisees or the potential franchisees believe it. They also say, oh, it's non-negotiable anyway. So, or they just think it's just a contract. Well, it's not just a contract. It's an entire legal dynamic that you really, really need to understand. If you just hire a breach of contract or like a normal business attorney or even a contract attorney, if they are not educated in franchise law and in specific franchises in general, they are not going to be able to properly evaluate the agreement because they do not understand the dynamic that is going on. And unless you understand it, it's impossible to review these agreements as a whole and advise the client. Could you just review it and be like, yeah, I don't see anything in contract world that's out of place? Sure, 100%. But you're not going to be giving the client the best advice or the proper advice if you don't understand the dynamic and you don't understand the field of franchise. There's a lot that goes into it. There's a lot of legal nuances. There's different state laws. There's federal laws. There's all kinds of things that go into it. And there's also a lot of things that you're just not going to pick up on unless you have the experience. So I call that my red flags. When I'm reviewing an FDD or a franchise agreement, I know exactly what to look for. I've done this for 23 years. I know exactly the dynamic I'm looking for. I know exactly how they like skirt around things with words. I know key players in the franchise industry. One of them, I had a client gave me a FDD for review and I had not seen this franchise before. I got 10 pages in. I wrote no in red on it, called the client back and said, I can tell you, I charge a flat fee of $2,000 to do with this. I said, I'm only maybe $400 in this review. And I can already tell you my answer is going to be no. I said, I can finish the review or I can stop here, tell you why and refund the rest. And she wanted me to finish it. So I did, but I knew the key players. I knew exactly the people that were being disclosed. And I knew I don't care what that contract says, there's going to be zero way I would ever recommend anybody signing it. There's also been franchise systems where people are like, hey, what about this? And I can tell you for free, the answer is no. Like, you don't even need to pay me. I can already tell you the answer is no. So it's just stuff like that, I don't know why they don't come to franchise specific attorneys, other than it's just a weird combo of a crazy unregulated sales process.
Yeah, I recently was speaking to a franchisee who was telling me their story, and they were talking about their initial sales process and how they had met up with this broker from a well-known firm. And when it came time for the franchisee to say, "Hey, I'd like to have a lawyer look everything over," the broker's like, "Oh, no problem. We've got, lawyers, CPAs, anything you need to have, look over your documents for you. We'll make it easy for you." Well, it turned out this franchisee found out later that it was a law firm that had two different sections. Some represented the franchisor, some represented franchisees, but they also created the documents that they were just reviewing. And nobody told the franchisee about the conflict. And so that's something I've actually seen that 3 times just in the last 4 months from people telling me about this. I'm like, that is a huge problem.
The reality is the entire system's unregulated. Why? I don't know. To me, it's absolutely insane. If you think about the investment world in general, which a franchise is just an investment tool, right? But if you look at all the other investments options that you have out in the United States, every single one of them is highly regulated. Banking, real estate alone, just those two, right? Then you have like stocks, bonds, all those kinds of investments. Then you have franchises, which is a weird combo of all three with no regulation whatsoever. It blows my mind. And they tout that they're highly regulated. In reality, they have one rule that they're supposed to follow, and it's called the FTC amended franchise rule. And the reality is if they don't, absent a few states, there's nothing I can do about it because there's no private cause of action for it. Then I'm really going to get on a soapbox here, by the way. Then you throw in franchisors are also putting arbitration clauses in their agreements. Okay. So now, even as a franchisee, if you want to do due diligence, all the disputes have been made private. So there's no public ability to even check if what they're disclosing is actual reality. And arbitration is incredibly expensive, and franchisors know it, and they keep putting it in their contract so to dissuade people from actually pursuing valid claims. If the good franchisors don't start taking action to get the bad ones out, the entire franchise industry will collapse. Mark my word, it will.
Yeah.
You can fix it with 2 things. Give a private cause of action for violating the FTC, because right now only the Attorney General can do it, which is completely useless, and get rid of arbitration clauses. Those 2 things will level the playing field and get the bad franchisors out of the system, which is destroying the good franchises.
Yeah, no, those are excellent points. You're spot on with all of that. The arbitration clause has really ruined so many lives. It makes it so hard for incoming franchisees. When you're doing a document review for somebody and you're looking through the FDD, so where do you start? Do you just start at page 1 and just start reading?
Sure do.
So you go item 1 through 23.
Yep, I use a color-coded system. So I use blue for just language I want them to be aware of. Green is language that is good for them. It's either something positive that is maybe not normal in the franchise world, or just language that is good for them in court. So if something were to go wrong, this is enforceable language. And then I use red for things that I want them to be warned of. It's not necessarily like do not proceed if you see red. It's more so just I want you to be aware of this. It can also be bad language, meaning this language is not really enforceable in court. Okay, so for instance, I often see after people have signed and they come to me and they're like, oh, they said they were going to do this and they said they were going to do that and blah, blah, blah. Okay, great. You know what your contract says? It says they may at their discretion. It's just stuff like that. So I read every single word. And here's why. It's not just reading the words and identifying the words. In order to do a proper FDD and franchise agreement review, you need to read the document as a whole, because it's giving you a whole picture. and you need to read it as a whole to understand the entire thing. What is going on and what certain paragraphs are referring to and mean. And the footnotes are often very important. So I read every single footnote. I make sure sometimes I read the FDD and it's different than the franchise agreement. So the FDD will say one thing and the franchise agreement will say another thing. So then I point that out and they take it back to their franchisor and say, which one is it?
I see it a lot in jurisdiction. So the FDD will say our disputes are going to be here, but the agreement says someplace else entirely.
I've had the non-compete be different in one versus the other. I've had the jurisdiction be different. I've had the advertising, marketing fund be different. Not by a lot, but it's enough that it's like, okay, well, what is it? Like which one is it? You're saying it's this, but then your contract says this. And I'm sure it's just the poor attorney who's drafting it is 300 pages. And I'm sure it's just they forgot to change it on one of the two. So it's never, I don't think it's necessarily like they're trying to trick you kind of thing. I think most of the time it's just there's a disconnect between the two and some drafting issue. So we just need to get it adjusted.
So when you're looking at an FDD, which sections immediately signal risk to you as a lawyer?
Probably the litigation section where they're disclosing any prior lawsuits. That's probably a pretty high one. The item 19 disclosures, that one I usually look at very carefully if it's in there. I'm not a huge fan of them. I have seen very, very few FDDs where I feel like the item 19 disclosures are not skewed. Okay, meaning they're not taking information and putting all these little footnotes in there to paint a picture that is not reality. I've seen very few that are not that way. And then lastly would probably be the open and closure of the franchise system. So I like to watch and see trends. How many closures are happening each year? Is that on an uptick? How many transfers are happening each year? Is that on an uptick? How many corporate take-back locations are happening each year? Is that on an uptick? How many new franchisees are coming into the system? Is that on an uptick or down? And that can be a positive. But if I see we were at 15, now we're at 50, now we're at 100 in 3 years, it's an immediate red flag to me. And I warn the franchisees because that kind of growth is really hard to sustain. So it usually results in problems within the franchise system very quickly. Slow and steady growth, A-okay. Rapid growth, terrible for franchisees. Might be good for the franchisor for their pocket, but it's terrible for the franchisees because the franchisors are never set up correctly to handle and support that kind of growth. This is why it's important to look at it as a whole, by the way. Those are where I often see the red flags, but really it's looking at all three of those things together that gives me the full picture of what's actually going on. And I tell people to read between the lines. Okay. They're hiring an attorney to draft that FDD for them to quote unquote comply with the law. But there are a lot of ways to polish a turd. Okay. You can make anything look good by just changing the way you say it. All right. So sometimes you have to read between the lines. You have to read and try and figure out okay, what are they? That's a weird way to say that. What are they trying to say in reality? So it's definitely, you cannot piecemeal it, but those are probably the sections that I focus the most on when looking at the picture as a whole.
So we're talking about the franchise agreement a little bit earlier, and I want to touch on the idea that franchise agreements are not negotiable. Now, I know that to be false. You can negotiate pieces of it. So kind of walk me through that process and like what are the main things that you pick out that you try to negotiate for a franchisee?
So it is absolutely false. They are negotiable. I hate when people say that they're not. There are certain things that I would say they're not likely to negotiate. And some of this also depends on how established the franchise is. So if it's a newer franchise, you have a lot more negotiation room. If it's a more established franchise, you have way less. But regardless, you still have room to negotiate. You can negotiate things like territory is a huge one. Territory is a very easy negotiation, which by the way, like it blows my mind some of these territories. Everybody likes to put in the territory, what I call the McDonald's territory, which is like your location and a mile parameter or, surrounding your location. But they're like a high-end salon. Like you're not McDonald's. Like you can't, that's impossible
Right.
for a franchisee to be successful in a mile radius for this niche franchise that you're offering. You can absolutely negotiate territory. You can negotiate certain terms. Like sometimes we ask for the arbitration clause to be removed, which has happened. Because what I tell them at the end of the day is even for the franchisor, arbitration is incredibly expensive. It's touted as a cheaper, faster alternative. That's BS. It is absolutely not cheaper and it's absolutely not faster. In reality, arbitration is exactly what it's a company. It's designed to make money. It's not a court system. Do I think it has its place? Yes. Do I think it has its place in franchise agreement? Absolutely not. I've had the time frame of the franchise adjusted. Also, some things are a little bit easier when there's transitions going on. If you're buying an existing franchise, sometimes it's easier for us to negotiate things in that aspect because the numbers and everything are based off of the previous franchisees' numbers. So sometimes we can get it adjusted in those circumstances because kind of get like grandfathered in kind of thing.
Is that negotiation phase, is that a part of your $2,000 fee to review that's additional?
Correct. That's additional. So the $2,000 fee that I charge is me reviewing the FTD and the franchise agreement, and then an hour consultation afterwards to kind of go over what I found, answer any questions, give them some feedback on here's what I think you can push back on. If they want my assistance in negotiating and or reviewing any adjustments to any contracts later, I just charge hourly for that.
So basically, it's not that nothing is negotiable. It's that people need to have realistic expectations moving into this process.
It is so important to understand the dynamic you're about to enter into so that you can be successful. I had somebody tell me that their plan for this business, they were thinking of this franchise as it's my business, okay, which is mistake number one. I'll tell you right now. Mistake number one, it is not yours. It is theirs. You're just operating it.
I think a lot of that comes from the sales narrative because they're out there pushing, be your own boss, own your own business. Here we've got a system you can just plug and play. And so they get that mentality like, this is mine. I get to call the shots and you can't.
But I had somebody say, I said, what's your long-term plan? And they're like, well, I'm going to pass it down to my kids. And I was like, if that's the way you are entering into the franchise world, you've already started off on the wrong foot, right? Because you're looking at this as it is your business and it's not. In reality, what a franchise is it's an investment vehicle. Okay. If you go into it with that mindset, it drastically changes your goal with it. It changes the dynamic too. It takes the heart out of it, which it should. Like, yes, you should have some heart in the business that you're doing. But when you are first entering into this, if you are entering into it with the mindset that this is my dream to own my own business and do all this stuff, you have already started on the wrong foot. But if you enter it into it as like, yes, that's what I want, but this is an investment tool, an investment vehicle to get me to where I need to be in life, that is a much different mindset and it's easier to navigate the franchise world if you go into it with that mindset.
So we've got a franchisee, you've looked over their documents, everything's been negotiated, they sign, and then they've got their honeymoon phase and everything seems to be working, and then things slowly start dropping off. So what are some of the common issues that franchisees are coming to you with after they've already signed and they're in the system?
Lack of support is by far, hands down, the number one complaint.
On the franchisor side, is that something that would trigger a breach of contract on the side of the franchisor if there's a lack of support?
It can, yes. It depends on the franchise agreement, obviously, but it absolutely can. I have had it. We've literally won cases on it, so it absolutely can be a problem because they do have legal obligations, right? Like the franchisor, from their perspective, they also need to be looking at this as this is an investment tool I'm giving people to operate. In order for people to be successful in operation, you have to give them the tools to do so, right? They're dependent upon you. It's when the franchisee and the franchisor works together, it works beautifully. Okay, everybody wins. The problem is when the franchisor starts to just focus on itself and not worry about the franchisees and their success, that's when things start to turn. So lack of support is a huge, 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 huge thing. These franchisees are dependent, for lack of a better word, upon you as the franchisor to give them the tools to operate. And I understand everybody's a little different. So some people's idea of support means that you're literally in bed with them, helping them get out in the morning. Like it's a little overkill, where others are just, it's the exact opposite. So the franchisor, I do understand that some franchisees may be a pain in the butt, but as a whole, if you've got multiple franchisees coming to you saying, hey, we're not being supported. Hey, everything you're doing is actually harming us. For the love of, just freaking listen. They're telling you what is going on and you're not listening. And that's when things start to go really, really bad very quickly.
And oftentimes they're telling the franchisor exactly how to fix it. So even if you have a newer franchisor who maybe doesn't have the tools to do that, these franchisees that you've put in place, they have more experience than you, a lot of them do. And they're telling you exactly what they need to fix it.
It's mind-blowing to me sometimes. My favorite thing to do in franchise world, it happens very rarely because normally franchisors aren't willing to listen. My favorite thing to do is get in there early and I can see what's happening. I've done this for 23 years. Like I can tell when a franchise is about to fall apart. I will literally warn the franchisor, it's coming. I've done it. I've seen it. I know exactly what's going to happen. And I will give them the answer. 9 times out of 10, they don't care. It's unreal. But in reality, like it's not what the franchisees are asking for. And even my suggestions when I'm giving them like, hey, here's how you can fix this. It's really not that big of an ask, right? It's not like we're like, oh, you have to invest millions of dollars and do this, that, and the other. It's usually just like, let's pick up the phone. Let's call them. Let's figure out what's going on, right? And then looking at different territory. Like a lot of times, like the model might be successful in a city, but you put it in the rural area and it's epically failing. Pay attention. Stop selling in rural areas if it's not working. Like it's just mind-blowing to me. And that's honestly the only time I've ever considered doing something on the franchisor side. It's not necessarily representing franchisors, but kind of acting as an intermediary when the franchisor spots like there's issues arising, where I can come in and go, okay, here's what the franchisees are seeing. Here's what you're seeing. Here's the actual reality. And then providing a solution so that everybody can move forward. Because a lot of times The other thing I found, Genevieve, is that it's a lot of just miscommunication. That's what a lot of it is. So a lot of it's just me making sure everybody sees both sides of things and then finding a solution that's in the middle. But that's the only time I've ever considered doing anything on the franchisor side. It's just kind of because it inevitably would be helping the franchisees as well.
So if you've got a franchisee who realizes fairly early on, we'll say year 1, year 2, that things are not as they seem and things are not what they were sold, what are their real options at that point?
Well, that's the other thing people don't realize is that until they're in it, because they haven't had an attorney review it and tell them, is that if they shut down early, they could be on the hook for the entire term of the franchise agreement to the franchisor. Sometimes shutting down is not an option. My line that I typically tell franchisees is the good news is you have options. The bad news is they're all bad. Our job is to choose the best of the bad to get you to good again. Okay. Kind of like going through divorce. You got to go through it. It's going to get messy for a minute and then you get to the good side again. All right. But that's what I tell clients. They do. I'm going to give you the classic attorney answer and tell you it does depend. It depends on a lot of factors. Sometimes I immediately tell them shut the doors. Like there's no way around it because they've actually been defrauded into the system. I have one that I'm dealing with right now that they're trying to enforce a franchise agreement. And I said, where is it? It doesn't exist. There's no franchise agreement whatsoever. There's a like a 1 paragraph addendum to an existing franchise agreement that they gave a FDD that was dated in 2022 to this franchisee in quotation marks in 2026 that had him sign 1-page addendum replacing the franchisee in the existing agreement. But it really does depend. It depends on what state you're in. It depends on how long you've been in the franchise system. It depends on what the status of the franchisor is. Are they, in turmoil? Are they going through bankruptcy? Are they, in growth phase? Are they highly aggressive? There's a lot of factors that I evaluate when franchisees come to me going, hey, Kelly, I've done a terrible thing and I need to get out. So I have to look at all of those things and then we come up with a game plan. And I tell clients all the time, you're going to have to be okay with pivoting. I have no control over any of this. The only thing we can do is make that first step and see what happens. And then we pivot and pivot and pivot and pivot until we get to the resolution. Sometimes it's quick and easy. Sometimes it's a 7-year battle. So it depends on what's going on.
So under what kind of circumstances would a franchisor put a franchisee under default? And what is a notice and cure period?
So those are all typically outlined in the franchise agreement itself. There's a lot of areas of default, failure to pay the royalty fees and advertising fees or any other fees for that matter, failure to open in a certain time frame. So the other thing I do when I do the review is I notate in the document like, hey, calendar this, hey, calendar that. Like these are all time frames you have to pay attention to. So don't open in a certain time frame, operating outside the territory without permission. Those are probably the most common. Failing to pay fees is by far the most common. Everything else is just like you can be in default if you file for bankruptcy. You can be default if there's certain lawsuits that are filed against you. You can be in default for failure to operate the system according to the operations manual. So let's say they say your hours have to be from 9 to 5 and you refuse and you're like, my hours are 10 to 2. If you're not complying with what what it says that you have to operate in, then they can put you in default. Some of them are what we call curable defaults, which means they give you notice and then you have so many days to cure. It depends. It's typically 30 days, but there's also, I've seen 10 days, depending on what is being defaulted. I've seen up to 60 days. It really kind of depends on what exactly they're accusing you of, but there's typically a cure option. Not always. Some of them have an immediate default. It's usually pretty substantial to do that, but even then it's not really quote unquote immediate. It sounds immediate, but it's not really immediate because welcome to law, nothing happens quickly. So
What happens then when they are placed in immediate default or they can't cure the default within the time frame?
So typically lawyers obviously get involved and we're negotiating and trying to find a resolution. Sometimes, once again, depends on the situation, but I've seen where the franchisor reserves the right to come in and operate the franchise, and they reserve the right to take over the franchise and all that stuff. So they will come in and actually operate in some circumstances. And then in the meantime, the lawyers are talking to try and find a resolution. That very, very, very rarely happens in my experience. In reality, what usually happens is we're just negotiating how to resolve the dispute.
And then you've got a franchisee who just, he's been in default a few times. He's completely out of money. He hasn't been paying his royalties because the sales just aren't there to support it. And he decides to close up and just walk away. So what are the financial consequences of doing that? And then how does their personal guarantee play into that, just walking away? Because they're broke at this point.
If you just walk away, your franchise agreement either has what we call a liquidated damages clauses in it, or they'll pursue you for breach of contract and claim damages for what your average royalty was or your average marketing fee was times the remainder of your franchise agreement. So if on average you were paying or supposed to be paying $1,000 a month and you have 48 months left on your franchise agreement, they're going to say, okay, you closed early. Your penalty for closing early is $48,000. So you owe us that. There's sometimes a liquidated damage clause in there. There's always a provision for attorney's fees in there. And then the personal guarantee means you're on the hook personally. So yes, the contract might be with your entity, and yes, they could go after the entity first, but in reality, they know the entity doesn't have anything. So they're going to go after you personally. And if they got your spouse to sign, they're also going to go after your spouse and all your marital assets. So that's why the personal guarantee is there, so that if you fail, they can still go after you personally.
And that's when a lot of franchisees start eyeballing bankruptcy as an option.
I've seen an endless amount of bankruptcies, divorces, and even suicide over this stuff, which I can assure you the last one is not worth it. So a lot of times when I'm talking to franchisees, it's a very emotional conversation. I've had grown men just bawling their eyes out on the other side of the screen from me because they're losing everything. Their marriage is in shambles. They can't support their family. Like it's bad. And I have to talk them off the ledge, talk them back to here's what we're going to do. And, sometimes it's a very emotional ride for people.
Yeah. So, the biggest takeaway from that then is that walking away doesn't make the obligation go away at all. Yeah.
Yep, absolutely.
A lot of times there's suspected fraud. So in the sales process, that's low hanging fruit for me. So in the sales process, you've got suspected fraud. You've already signed the deal. If the franchisee believes that they were misled, how does that change things from a legal standpoint?
I can tell you, because this happens very, very frequently, where I get calls like I've been defrauded. I've done all this. Like they told me this, they did that, blah, blah. Here's the problem. Fraud in the way we all use it, I agree 100%. There is zero doubt in my mind that, yeah, you were misled and yeah, you were defrauded in the everyday parlance of the word. Okay. In a court system, proving fraud is an incredibly high bar. All right. It is, like I said, we've done this for 23 years. I've had fraud, negligent misrepresentation, fraudulent misrepresentation, any of those kinds of claims stick maybe 3 times. They almost always get dismissed. What you're telling a court is they told me this, but I signed a contract that said this. I also, by the way, signed a contract that said I'm not relying on anything they told me. So it's really, really difficult. Now, the ones that I've been able to keep it in, and even this can be difficult, by the way, I will also say it depends on the state and the judge and a lot of other factors. But the ones I've been able to keep it in is when I can prove without a shadow of a doubt that the entire, well, a significant majority of the FDD they received was false or misleading. I've had ones where I can prove certain facts are actually false and it still gets kicked out, because what happens is the judge looks at it, goes, okay, you're telling me in a 300-page disclosure document that but for these 2 little minor facts, you would not have signed the agreement. It's a really hard sale. So it very, very, very rarely sticks. Do I still bring it? Yeah, 100%, because I do believe they have been defrauded most of the time, but it's a hard sell. And you also have to factor in sometimes the fraud occurred with a outside company, not the franchisor directly. So within the franchise consultant or the broker, the third party sales process, they're the ones that actually quote unquote defrauded you. So then it gets tricky there where it's like, okay, which one are we suing? Are we suing both? What are we doing? There's a lot of moving parts when I'm assessing legal claims and situations within franchise systems. There's a lot of legal moving parts to it that have to be carefully analyzed and each step carefully planned out.
It's an expensive process to litigate these things. And I think how do you explain to the franchisee that, hey, yeah, your claim is worth, $300,000 or $500,000, we'll say, but it's going to cost you $150,000 to litigate. And there's no guarantee at the end of the day that you're going to get a judgment, or if you do get a judgment, collect on that judgment. So how do you prepare that franchisee in that initial conversation about the prospect of litigating on this?
I give them a harsh dose of reality. Unfortunately, I also have to factor in that sometimes the franchisor that we're suing doesn't have money. And I tell everybody that a judgment is a very expensive piece of paper if you can't collect it. So we could go forward and we could win, but that doesn't mean you're going to collect it. So then you spent all this time and money for a literal piece of paper. Each situation is evaluated very carefully. And I've always explained, here's your risks. But the reality is they have risks if they don't do anything at all. So it's sometimes you don't really have a choice. Like, we have to take the risk a little bit to see if we can get to a point where we can get to a resolution that you can live with. It very, very rarely actually goes to trial. Most of our cases end up not just our cases, most cases in general, franchise or not, end up settling. So there's always that, but I have them carefully evaluate. I do a lot of different creative things to help level the playing field. So group actions are probably our number one thing that we're really good at, where we will group a bunch of franchisees together with identical claims, and it helps mitigate the cost to litigate. Sometimes I stay behind the scenes and the franchisor actually has no idea I'm even involved. That one tends to help a lot sometimes, because the second I come out front, their attorneys come out front. They're usually attorneys at big firms with minimum billable hours. So we usually end up fighting over stupid stuff that we shouldn't be fighting over. So just stuff like that, like you have to, it's each situation is drastically different. And sometimes the way we start out, the way we end up is different than where we start. That's why I tell everybody you have to be okay with pivoting, because I mean, we can make the first step. And some of the cases that I thought, and like, if I'm being honest, I'm like, this is an uphill battle and it's not looking good for us. Okay. Have settled in less than 60 days. I'm like, okay. And then like slam dunk cases, in my opinion, like absolutely slam dunk cases, battle for 7 years. Like, it makes no sense. And I gave up trying to predict anything. And I just tell people, be okay with pivoting. I have no idea where it's headed.
Yeah, it sounds like you're a master at helping people manage their expectations.
I really, really try. To me, especially in this circumstance, they've already had somebody blow smoke up their skirt and, quite frankly, screw them. The last thing they need to be doing is going to an attorney who's going to do the same to them. So I do give harsh reality. I do tell them you only have bad options, because that's reality. I'm not going to lie to you. I'm not going to say everything's going to be okay. Will it eventually be okay? Yes. Is it going to suck in the meantime? Absolutely. Sometimes I tell people, like, I go, listen, here's the deal. Are you probably going to have to pay the franchisor some money? Yeah, you sure are. But so far, you've paid them thousands and thousands of dollars, and they've done absolutely freaking nothing for you. So why don't you at least make them work for it? It really depends on the situation, but it's a very tough dynamic. And I do not lie to people. I do not, if you haven't figured out yet, I do not sugarcoat things. When I'm not being recorded, I cuss like a sailor. So there's that.
So in the whole process, so from a buyer first looking at a franchise all the way to the end. So when should they first call you?
Probably when they have the FDD in hand, they've received it from the franchisor. I don't necessarily need to know, like, oh, I'm looking at this one, that one, or the other one. But once you have narrowed, or you think you've narrowed down, this is the one I'm interested in, and you have that FDD in hand, that's when you need to reach out to me and set up a time for the initial consultation where I just introduce myself and all that stuff. And then I'll do the review. The other thing I will tell people, if they are telling you, hey, here's the FDD, giving you on this date, once you have the FDD, you have 14 days before they can ever have you sign anything or take any funds from you. That is an FTC rule, okay? Do some people break it? Yes, they do. But the reality is you're supposed to have that 2-week window. That does not mean on the 15th day that you must sign. It means you have to have a minimum of 14 days. So if the franchisor is like, oh, it's going to sell, oh, it's going to do this, and you're feeling like it's in a high pressured sales situation, there's red flag number one.
Yep. There you go.
It should not be a high pressured sales situation at all. So, but once you get that FTD, that's when we talk. That's when we set up the consultation. That's when I do the review. And that's when I get it back to you and you re-review it with all of my notes. And after our conversation, and then you decide, do I want to go forward with this or not? Do I want to make some adjustments to it or not? Do I want to negotiate anything? And then go forward from there.
So buying a new franchise and building it out, or purchasing one that's already built out and is being resold by the existing franchisee. So does that change anything between the two sales processes, a new versus a resale?
It does. It actually adds a different layer to it. So I usually charge $3,000 when I'm doing that, because I also have to review the agreement between the franchisee and the previous franchisee and the potential new one.
Are you also looking at the financials of the existing location on a resale deal?
If they ask me to, yes. Typically what I'm doing is on those particular things, I have them gather them all and use a CPA to review and look at and make sure the numbers are matching and everything else. I also have them pull, we get the numbers from the franchisor too. so that we can cross-reference to see what the previous franchisee telling us also what's being reported to the franchisor, which is just a good way to triple check numbers. I don't know enough in that area to give you a full opinion on them, which is why I usually bring in a CPA for that part of it. But I've done this long enough that I know when the numbers look funky and something's missing or something's off. Same with franchisors, by the way. Their financials, the item 19 and their item 21. Is that right? I always get the numbers mixed up. Anyway, their financials and the item 19 financials, I can often look at those too and go, this is not adding up. What they disclosed and what's over here are two different things. That is where it's different. So we have to review the FDD and the franchise agreement to see if you want to even enter into that potential relationship. Okay. Then I have to review what is going on with you and the previous franchisee. And is that agreement actually covering everything that you're trying to accomplish? So it does require more when we're doing a purchase of an existing location, because we have to take over the lease. There's usually a lease. There might be other long-term contracts in play that we have to review and take over those. There's a lot of little contracts that come in, and then making sure all of the terms are outlined is a lot more work than just reviewing an FDD and a franchise agreement from scratch.
I just have one last question for you before we wrap everything up. So if there was one question that you wished every franchisee would ask you, what would that be?
I honestly, the one question and I'm not going to say it's what I wish, it's what I hear the most. I wish I would have come to you before I signed this. I hear it every day of my life, because most of the time I could have avoided this situation because I can see the writing on the wall. Does that mean 100% of the time? No, absolutely not. A franchise is a very dynamic system, and it can be sold off, and you have a different franchisor all of a sudden. I would say 9 times out of 10, the people that are calling me that said, I wish I would have known you before I signed this, I would have absolutely told them not to sign it. So that would be my one thing, is I just wish franchisees would hire franchisee attorneys who are looking at this agreement and truly advising them on the reality of the situation and the dynamic they're about to enter into. Because I do think franchisees can absolutely be successful, but you must understand the dynamic in your legal rights before you get into it. Otherwise, you're setting yourself up for a real struggle bus.
Well, I really appreciate you sitting down with me today. This has probably been one of my favorite podcast conversations. You're definitely a gem in this space.
Oh,
and I, for one, am glad that you're here. And tell my audience how they can get in touch with you.
So our website is just www.fortmanlaw.com, which is FORTMANLAW.com. Our phone number is on there, which is 314-522-2312. There's a contact us page where you can send us whatever, and we'll reach out to you and get you on an attorney's calendar. Pretty easy. We're also all over social media and LinkedIn and everywhere else. So you can pretty much just Google my name and it will pop up. So it's pretty easy to find me.
This is exactly why I tell people, this is not just about picking a brand you like. This is about understanding what you're agreeing to legally, what you're stepping into financially, and what your options are if things don't go as planned. Legal review and due diligence are not optional if you're making a 6-figure investment. They're protection. If you're in the process and want help breaking down a franchise before you sign, you can find me at franchiserealitycheck.com. And if you haven't already, make sure to subscribe, because this is exactly the kind of information that most people don't get until it's too late. We'll see you next time.